situation. Well, I'll ask about that. No, I'm good. Thank you.
Anything else? You have comments, Senator?
Your application coming soon? Never mind, I'm just kidding, got it. Hope so.
Counsel,
How's that?
can I ask you something?
Yes.
When's the last time you had a trial with
I don't know about trial, I can tell you that the dangerousness hearing is pretty extensive, dangerousness hearing that we had.
I mean, a trial? Or a hearing?
With Doug, I don't think I actually went to a trial with Doug. And one of the reasons, you know, as most of you probably aware, that the majority of the cases in district court don't go to trial. So we're looking at a much smaller number. So the one thing that Doug did know, he knows how to value the case. He knows what the case is worth. And when he came to try to resolve the case, you know, he knew right away we were in the same ballpark as far as the disposition. But he also knew if he was going to try the case, you know, we would have had numerous pre-trials to continue to wait and see if the Commonwealth's case got strong. We could. He was able to value the case and put it on for trial rather quickly if he knew we were going to try the case.
Okay, but you didn't have any trials with the district?
Not trial.
You have pleas with?
At many pleas.
When's the last time you had a plea?
Well, probably just before he became assistant court magistrate.
And were these agreed pleas or unagreed?
I believe the last one, there was a defendant that had, I believe, 7 cases that were resolved. It was agreed.
And how many pleas do you think you had run over the course of his experience as a lawyer?
Probably
700?
several.
Several hundred?
Several.
Like 200, 300?
Yes.
And, this was all district court?
This,
Thank you.
Just kind of to follow up that. The several one, you know, because I don't know, seven. What was the question? And I know the answer was 700. What was the question?
how many pleas?
Okay. With respect to, so you had a lot of cases with Doug. Did you ever notice, and let's be fair, we all know, we look at judges and defense attorneys and assistant DAs, oh, he's a good judge, a bad judge, a tough judge, a mean judge. That's everybody does that. Did you have many occasions with Doug, obviously had several hundred cases, where he didn't want to appear in front of a judge and would try to request a continuance, and he had that gut feeling the only reason he wanted that continuance because he didn't want to go. And I'm sure it wasn't this judge, or the, it wasn't Judge Kenyon. But you get my point.
And did he judge shop?
Yeah.
No.
He did not.
No.
And let me ask this. That's a question that I've been asking for the last 3, 4, 5 weeks. Obviously, the court wants to move cases. And my understanding is that, you know, continuance, sometimes the judge may assess either defendant or the defendant's attorney court costs. Because the police officers here, witnesses, put time out of work. What's your feeling about Judge Shaw? Good idea, bad idea, give me a sense, he didn't do it, but what do you think?
I'm not in favor of judge shop.
Why is that?
You know, because the case is what it is. I mean, you know, there's a lot of work that goes into putting the judges on. You've got to have a certain amount of respect for those judges that are up there in their decision making. Regarding judge shopping, if the defense counsel wants to try to tender a plea in front of a certain judge, and it's not going to accept it, they can always put it on for trial. You know, case facts are not going to change. You're going to have a certain amount of respect for the judges that are up there.
And I know you're not the nominee, but just on this issue, you feel that every judge in the Commonwealth rules the same way, every motion? Some judges more lenient, some more difficult. And again, I don't do criminal, I don't do anything, I don't go to court. Motion to suppress, if you went in front of this judge and it was allowed, and this judge who was, yeah, no chance, would you rather go if you were a defense attorney in front of this judge who has a reputation of being, I'll use the word fair, but giving defense attorneys a shot and allowing motions to suppress, would you rather go in front of that judge?
As a defense
Yeah,
attorney,
that's what I'm talking about, as a defense attorney.
as a defense attorney, possibly.
Well,
But you're asking me.
I'm asking, no, as a defense attorney, wouldn't you say, definitely want to go in front of Judge so-and-so instead of this judge over here who has a reputation of never allowing a motion? And and if it was a sentencing issue, and you know, this judge over here is a big proponent of community service, probation, and this judge over here is like, oh, lock him up, lock him up, lock him up. As a defense attorney, would you want to go in front of a judge who's either going to give you community service or probation or continuance without a finding? Would you rather?
As a defense attorney, I'd probably lean that way.
So based upon that, isn't it good practice for a defense attorney? Maybe said, in your opinion, that you don't believe of all the cases, several hundred, that J Darnbrough does judge shopping. But don't you think you should have?
Not necessarily. I mean, there's a difference between the attorneys that have tried to judge shop for that exact same reason that you just mentioned. And then there's the percentage of the attorneys that, you know, put their case forward and convince the judge that, let's say, you know, send that person to jail, stand up there in front of that judge, and with their skills, convince that judge that probation or some other thing is alternative. And that's essentially what.
Respectfully disagree. I'd be really surprised if, and I obviously didn't ask Kevin Reddington, I would be shocked if Kevin Reddington said he didn't judge shop. And I don't know, I just feel like if you don't judge shop, to me, it's malpractice. That's just my opinion. When I say Kevin Reddington, because I know who does that. Yeah, he left. I would assume he would judge Sean, because I think to be a good and effective attorney for your client, you better judge Sean. Again, that's what I would think, and I respect your answer, but we'll see if, when I ask Doug the same question, he was to say if you got it right on him, but I do appreciate it.
Well, what I can tell you is only from my personal life, not once, and that's what, the integrity that I mentioned earlier, not once a year come to me. I don't want to go from this judge.
I didn't say that though, I didn't say that, so, you know, put words in my mouth. But I know what, I think most lawyers, they want to go in front of Judge A instead of Judge B, they're gonna say, yeah, you know he's right. You got the gut feeling he's right. Oh, geez, Judge A just came out. Yeah, you know what? Let's see if we can put this. They're not gonna probably come right out and say, oh, I can't go in front of him. He doesn't allow the motion to suppress in years. They're not gonna do that.
Some of them do.
Okay, but I think most lawyers would give some type of reason, rationale that they didn't want to go in front of that so-and-so judge. This is my opinion. Thank you very much.
Anybody else? Can we just follow up on that? We've had two people nominated for the Supreme Judicial Court. Both of them, I believe, have indicated that it would be ineffective assistance of counsel. This lawyer didn't call it judge selection. But as a defense lawyer myself, Kennedy also, if we know that we're going to get sent to either courtroom A or B, and in courtroom A, there's a judge who has never said not guilty, always sends people to jail, why would we allow our client to help it to go before that person?
That trial.
At any time. But in a trial or a plea, yeah.
Well, at a plea, I mean, the plea,
mean, you can,
It's one
but
as an attorney.
you can, but then your client has to be working, as if this is another day, back to it again before some other judge. And some other judge might say, well, he's already had a whack at this, so he's prejudiced by that. But my question is, what were your, how many years in DA?
It's, 13 years.
Well, you certainly have had cases that were ready for trial, and the judge came out that you either knew was very sympathetic to defendants or not. And there would have been times you would sit down, gee, this guy is liberal as it comes in. So would you as a DA want somebody who was a little more of a DA's judge?
What I want and what I get.
Right, well, it's the way it is for all of us, but we at least try, maybe some judge selection is some sort of bad. It is bad.
I said I'm not.
Let me, see, is there anybody in opposition? Anybody want to speak in opposition? Anybody else want to speak in favor? Okay, we'll hear from you.
Thank you. Thank you, Council Jubenville, members of the Governor's Council, for having me here today. I'd like to thank Governor Baker, Lieutenant Governor Leo, for the nomination. Povich and Sharon Casey, for the conflict they placed. I'd like to thank the speakers, Judge Cunningham, Reddington, and Joyce, Mr. Coyne, coming. With me here today is my wife Cheryl, my friends Tom and Donka, John Macedonia, Lieutenant Lacoste from the Taunton Police Department, Taunton Code Officer in the Briggs. Thank you all for coming and supporting the nomination. My son Dylan, in his 10-year baseball camp in Stepford and Cole, is hopefully taking a summer class at the Mass School of Pharmacy. It's an honor to be here, and a very humbling experience for me. I hope that my application, my questionnaire, my essays, my conversation with you here today shed some light on what I am. I believe that my knowledge of the law, my knowledge of the district court, my experience, my compassion, drive, and temperament would make me qualified to sit on the Associate Justice Commission. I think in order to assess where I am, where I would like to go, it's beneficial to know where I've been. To give you a short biographical history, my grandparents all came here from England, Scotland. They all worked in the jewelry and textile mills. My father worked at General Dynamics for 35 years in a variety of positions, last in production manager. He was a veteran of the U.S. Army, serving in the 82nd Infantry Division. My mother first worked in a department store and then was a stay-at-home mom, focusing on raising my two older brothers and myself, strengthening deep family values. My parents believed in education and hard work. My oldest brother was an insurance broker. My little brother works as a manager. I graduated from Bryan College with a degree in business administration. While attending college, I worked close to 35 hours per week in different part-time positions. I worked as a landscaper, bartender, I loaded fruit and produce trucks in the middle of the night. I worked in a Sears retail store. When I graduated Bryan College, I worked as an insurance claims adjuster, assessing liability in slip and fall cases, motor vehicle accident cases, and eventually settling those claims. It was during these years, the time I spent with defense counsel for the insurance company, that I became fascinated with the law of the judicial process. I was fascinated with the nuances and the court. I attended law school at night for the first 2 years while working in the insurance field, and then I transferred to the day division. When I was in law school, I had the privilege to intern for now Rhode Island Supreme Court Justice Executive. When I first met Justice Executive, he was a district court judge. He then moved to the Superior Court and now the Rhode Island Supreme Court. He taught me to be honest, compassionate, and to always strive. Upon passing the bar exam, I opened my own law office in Fall River. The focus was on hard work and dedication to the law and my clients. In the 18 years I had in my office, I obtained substantial experience in criminal litigation, civil litigation, including trial. I practiced predominantly in Bristol County, but I also Plymouth and Barnstable counties. My clients range from a middle-class working person to a person deemed indigent and appointed. My practice was approximately 65% of the district court, 30% of the superior court. I also represented the other 5% clients in the probate and family court at times, in the Department of Industrial Assets. I believe I've conducted virtually every single facet of criminal litigation and civil litigation. I represented people charged with misdemeanors, drunk driving, assault and crimes, drug crimes, gun charges, robberies, burglaries, arson, motor vehicle homicide cases. I've accepted court-appointed cases in the Fall River District Court and the Bristol County Superior Court for most, if not all, of my career. I served on the board of directors for the Bar Advocate Program and for years as a mentor attorney for lawyers. My civil practice consisted of not only representing clients who were injured in small fender accidents, but also death cases and permanent disfigurement cases. I've been to crime scenes, visited clients in hospitals after a horrendous accident, dealt with families after loved ones died, and spoke to families about domestic violence and addiction. On the other end of the spectrum, during the latter years of my career, I also represented several businesses and condominium associations. I feel I was able to, and I still am, communicate with people, take the issues, and ultimately guide them according to the law and the facts. I felt I did so zealously and compassionately. I have a diverse background, not only in my life, but also in the cases of people. I feel I have a well-rounded practice and developed it through a very busy office. I treated everyone I dealt with courtesy and respect. Over time, I noticed a sort of imbalance in my life. I was missing out on some of the family values that I cherished. I was a young child, my father was suffering from complications of Alzheimer's. I was getting home very late, working on weekends, and I thought at that time there needed to be a change in my life. I also had a thirst for public service, and I had great respect for the judiciary and trial. In 2013, I applied for and was hired as an assistant clerk magistrate in the Taunton District Court. I've been there now for 3 years. In the clerk's office, I've been exposed to numerous procedural aspects of the court. I've presided upon and moved upon small claims cases actually with values up to approaching $20,000. Show cause hearings, civil motor vehicle infraction hearings, reviewed and moved upon applications for search warrants, arrest warrants, and I've made bail determinations night and on the weekend for people arrested after hours. I've made decisions that deal with people and the issues in society. I've decided civil cases where people are steadfast in their positions. I've presided over cases where people were pro se, presided over cases with a lawyer on each side. I've also decided what to do with an accused person before me in criminal show cause hearing. I understand now to a greater extent, the flow of business. The inner workings of the district court, through the processing of cases, the scheduling cases, the administration of the court, and the business of the court. I've also had an opportunity daily to sit with the judge many times, review the criminal file, and have the bird's eye view of the process. The judge's thought process, I've seen things that I like, things that I don't. It is a great position. With all respect to the people that hold that position, what I did not expect in my personal situation, what I could not foresee, is how much I miss the law. I miss the application of the law, the interpretation of the law, the nuances of the law. For 18 years, I was a courtroom attorney. Every single day, multiple courts, trials, hearings, plea dispositions. I was and always will be a student of the law. I attended classes, seminars at MCLE, seminars in the trial court. On my own time last year, attended social law classes. Also recently chaired and taught 2 MCLE classes. In my position as a magistrate, I miss the law. I love the courtroom, I love the judicial system. I enjoy serving the public, and I wish to expand my public service. Almost like a minor league pitcher moving up, co-pilot moving up. I believe my civil law knowledge, my criminal law knowledge, and now my knowledge as a magistrate can exercising that decision-making role would be helpful. When I practice, I would love to research issues and write memorandum. Trying to do that as often as I can now for small claims cases. I respectfully suggest to you that my work ethic, my respect for people, my respect for the process, being conscientious, having and exercising common sense, if you will, are all attributes I have to be an efficient member of the judiciary. I see the district court every day. It's a busy trial court division, and it's getting busier, it's getting more diverse. There are more cases being processed, more cases involving addiction. I have an interest in social problems and passion for social problems. I believe in good judiciary, an educated, diverse, compassionate, conscientious judiciary. I want to assume a greater responsibility, a greater role in the judicial system for the delivery of justice in the Commonwealth of Massachusetts. I would strive to improve the judicial system, always being conscientious, being honest, and I promise you I will be the best possible judge I can be. I ask you, members of this council, for approval and confirmation of the nomination. Thank you again. We will take questions.
Thank you, Councilor Duff.
Thank you, Chairman. Nice to see you here today.
Thank you.
We hear a lot of things about you, that you're a really nice guy and you've helped a lot of people. It seems like a pretty quick move though between the magistrate's office and the judgeship. I mean, being at such a quick magistrate is really big. Why would you want to give it up?
It is. It's a tremendous job, as I indicated, to all respect. Everybody I've worked with, and I've met with different clerks associations. They are tremendous people, and they do a tremendous job. My work is well. My personal situation is that I truly miss.
But aren't you dealing with a lot? I mean, that was one of the big
To a certain extent, the position, I would say it's three different aspects of the position. It's managerial, that I supervise with the magistrate, the clerical workers in the office. It's ministerial, that I assist the judges in the courtroom, preparing the docket, and orders from the court. And it's quasi-judicial in conducting those hearings. The aspect of quasi-judicial, which I enjoy the most, is a small percentage.
You were very successful in private practice, and you acquired a lot of real estate, so you must be fairly financially independent. Why not go back to private practice?
As I indicated, in 2013, the Attorney Reddington had mentioned this. I needed a change in my life. I was working extremely hard.
No, I don't mean to interrupt you, but I am going to, and I understand that. But what concerns me about this train of thought is that you would have much more control over your life and your time in private practice than you will sitting on the bench. I'm concerned that you don't understand the time constraints that may be put on you, especially as the dockets and everything get bigger and heavier. And you may be moved around to a different part of the state as needed, as more slash and burn happens in our courts on a daily basis. And so I respect greatly, because family is first, but it almost seems like you're painting yourself into a corner where you wouldn't be able to have the lifestyle that you're looking for.
Well, I have thought about it. I do appreciate your comments. I think I would. The essence of my practice back then, if I ever went back to it, is it became extremely busy.
But you'd be in charge of it, and you can hire associates to help you with that. I mean, when you have your own business, I have my own business, you have complete control over your time. And you can outsource it to whoever you like, however you like, whenever you like. When you're a judge in the district court, that is not the case. And it is becoming less and less and less the case as our courts are under more financial and time constraints. And so I really, I have to say, I deeply understand your motivation for time with your family, but I'm concerned that it's misguided in what the reality of this position is.
In my time within the district court, I certainly know the job of the assistant court magistrate, and I'm able to watch and see the other judges, what they do, the schedule, the business of the court. And I think, considering the role that the judges have, and considering my ambition and what I would like to do to expand my role, I think it would be a good fit. I'm familiar with the schedules the judges have, and I'm familiar with the work that they do, and I'm familiar with the work that I have done and my capabilities, and I would like to expand it further my role, and I think that it would be.
Okay. And you are the only person that would know that. You've spoken a lot and repeatedly about your family values. What does that mean?
What that means to me is, when I started out in my office, you start out, you have your own business, it doesn't matter if it's a lawyer's office or an agency. You want to work hard, you want to develop a good reputation, and you want to make money. I have to pay the bills.
Of course.
So I did that, and I worked hard. I made money. I believe I developed a good reputation, and I worked hard. Well, what happened is, when my wife and I had a child, I wasn't around a lot of times. I was coming home at 10 o'clock at night. I was working on Saturdays. I was working on Sundays. And to me, when I'm not home during the week, and then on Saturday afternoon, by the time I get home at 3 o'clock, and bringing him to a toy store and spending $500 on a video game, it didn't seem to me to be worthwhile. I'd rather be home doing things with him, and using that time more appropriately, more balanced in my life. My father was also ill. My parents were elderly. My father was suffering from Alzheimer's. That needed attention.
So family values means, because it's a term that greatly concerns me, and it gets tossed around, and you tossed it around a lot today. It means spending time with your family instead of, I mean,
Well,
you know,
I
spending
think-
$500 on a video game is mind-boggling.
Right,
But
well,
maybe
as an
that's-
example, but it's, family values encompasses a lot of different areas. It's an umbrella term.
Yeah, but what does it mean to you? This is my question. What does that mean?
It means to me, A, spending time with the family, B, developing a good reputation, a good connection in raising my child. I want to be a father to my child. I want to teach my child life lessons. I want to be involved with the aspects of my family. I want to be able to go to the cookouts, the birthday parties. I want to be able to be an assistant coach with him in baseball. Society is really changing. The world is changing. I want to be a role model and a father.
What do you think is the most dangerous thing changing in society?
Drugs.
Not guns?
I would have to say drugs.
Interesting. Do you consider the gun situation in this country a public health crisis?
I know the gun situation in the country is changing. Myself, I'm a believer in the right to bear arms, the Second Amendment, the 14th Amendment. I'm cognizant of that, the decisions by the Supreme Court, other decisions, the Honorable decision. I also understand, I'm not naive, that there is a lot of violence in the world. There are illegal guns owned by bad people. I also have family and friends that are gun activists, and I respect their right. They're hunters, they're target shooters, etc. And I do respect that.
Do you think they have the right to have automatic weapons or change their weapon to bring it up as an automatic weapon to circumvent the law? Does that fall under their Second Amendment right? And does that trump the right of children to be safe in schools?
I have been reading lately about the Attorney General's position on the copycat weapons. I understand both sides of that argument, that there's a right to bear arms. I also understand the Attorney General's position that it's a danger to the community. choice. We have to decide.
You think you have the right to have an automatic weapon? You think that comes under your Second Amendment right? And do you think that's what the four founders meant when they wrote it?
I'm sure that the four founders, did not have automatic weapons back then, and didn't know what they would turn into. I think that the right to bear arms is the right to bear arms. How a person uses it is how
And then you do think it's legal for people to circumvent the law and turn their weapons into automatic weapons? Because that's what the Attorney General is saying, is that you can't circumvent the law in Massachusetts.
Right.
But you just said that you think
Well,
that's okay.
I don't think people can change their own weapons.
But they can bring it to a gun dealer and they can change the weapon for them in Massachusetts?
I'm not privy as to how they change the workings of the pieces. My understanding of the copycat guns, if you will, is that they're how they manufacture. I'm not privy to people changing.
I think you're gonna need to know this if you're a judge. Do you think that the rights of gun owners trump the rights of children to be safe in the school or people to be safe in the cinema?
My desire is that people are safe. I want them to be safe. I think people should be safe. I also, as I indicated before, based on your question, I do believe in the right to bear arms.
Do you believe in a well-armed militia? And you believe a well-armed militia has the right to take up arms against a government that they feel is oppressing them?
I would have to say this.
And so then, following that logic, do you think that the men who took up arms as a well-armed militia and assassinated police officers were within their Second Amendment rights to do that since they're being oppressed by those government police officers?
No,
Because that is the logic.
what I meant by my prior answer is I understand the right to bear arms. It's a fundamental right, Second Amendment right, 14th Amendment right. I do not agree with people using firearms illegally.
Wait, I have got to stop you there, because that fellow who assassinated those police officers owned his gun legally, was trained by the US government to be a sniper and to kill people, because when you join the military, that's what you're signing up to do. And I'm not criticizing him, but these are facts. And he was in an open carry state where he openly carried his gun down the street in Dallas while he positioned himself as, he believed, the member of a well-armed militia to assassinate government agents who he felt were oppressing a segment of society. That's okay under the Second Amendment, and you've just defended that. I find it indefensible.
I believe there's a right to bear arms. I don't think it should be used illegally.
It wasn't used illegally. He had a license. He carried it down the street openly. And by your own admission, he was a member of a well-armed militia. That's what a well-armed militia is, sir. A well-armed militia is people who are angry with their government taking up arms by any means necessary to shoot literally that government down. And this is a public health and massive crisis in this country right now. And if you are going to sit on the bench and you do not think that drugs and guns are related and one and the same issues, you are gravely mistaken. And it gravely concerns me about your ability to sit as a district court. I know you're a smart man and a nice guy, but these are the biggest issues of our day. We have first and second grade baby children in classrooms learning to hide when a gunman comes into the class to kill them. And you're telling me that those gunmen's rights trump those babies. I don't believe it. I believe as a citizen of the United States, I have the right at all times to be safe. And if someone wants to own a gun, as they do in my neighborhood, in my community, in my family, to hunt, to have a pistol or a shotgun to keep themselves safe, to skeet shoot, they have every right to have that. But no American has the right nor the need to have an automatic weapon or mutate the gun into one. And it concerns
understand firearms, prohibitions on firearms, automatically, certainly nominated, confirmed by that. There are illegal weapons, they should not, people should not have illegal.
In this country right now, we are in a crisis, and we are on the verge, if not already, in a civil war. We are. And if anyone thinks we're not, they are gravely mistaken and have their head buried in that sand. We have men and women who are bound to protect us as officers of the law being assassinated by people who we have given the right to assassinate them. Not only that, our government is training them how to do it. It's mind-boggling to me. And yet the NRA is silent on it, the Congress is silent with a few exceptions on it, and the government and this governor is silent on it. Well, they have their rights, the Second Amendment. It's mind-boggling. But the biggest challenge, and this council is being faced with it every other week right now, as we vet people to be on the Supreme Judicial Court, is that the state courts, and at the level, the basic level of the district court, matters so very much now as the law and the mood of the country changes. We cannot depend on what is happening on the U.S. Supreme Court to be the law. States are shifting, everything is changing. You have to be able to go with it. And it makes these jobs so much more important in the thought process has to be much deeper, into much more minutia than it has ever had to be before. It really is, and it very deeply concerns me that you have not given it that level of thought of what this really means. And honestly, in the sake of time, I'm not going to ask any more questions because I'd have you here all day, honestly. But this alone, I have to tell you, Attorney, it really, really deeply concerns me. To say, it's like saying to me, and some of the candidates have said it's settled law. There is no settled law in this country right now. And if you think there is, you are not living in reality. There is no settled law in almost anything. Rights are stripped away from people. People are killed and assassinated. We not only have a drug crisis, but that drug crisis is like this. It is intertwined in the gun crisis. And it is a public health epidemic, gun violence in this country, on par with the opioid epidemic, on par. But the fact of the matter is, the most of the people being killed by guns are not white kids. They're black and brown and other kids. The very people that the people in blue are sworn to protect, they're at war with each other. And it is a massive, massive social problem that we have. But I don't profess to know how to fix it at all, because I think, frankly, I think this country missed the boat when someone tried to kill President Reagan, who, by the way, his would-be assassin is being released from prison. Isn't that interesting? A white man with a lot of money who could afford a good attorney, who tried to kill the President of the United States, is being released. Wow. You talked about justice. That's it. Thank you.
Thank you, Mayor. Thank you, Paige. Thank you, sir. I've known you for the record for over 20 years as a defense lawyer on the other side of me on many occasions, I'm sure. I don't recall the exact cases, but I was a cop for 30 years, police chief for 9, and you were a criminal defense lawyer. And I always respected you, and I've never heard a word. And I'm here to do a job. My job is this, very clear. Decide whether or not you are qualified to be a district court judge in the Commonwealth of Massachusetts. And I just heard my friend and colleague, Councilor Duff, I think misinterpreted some of what you said. And for clarity, I'm going to ask you a couple of questions. Is that okay? Sure. Do you believe in the statutory scheme of the Commonwealth, where the police chief has discretion on whether or not to issue a gun permit and determine whether a person is suitable?
Yes, I understand that process.
Tell me your understanding of the process, how it works in Massachusetts, the edification.
The law has changed, I believe, in January 2015. This changes the application process. If the person applies for an FID card, or conversely, if they have an FID card and is looking to be suspended or revoked, there's a new form that's filed with the district court. There's 2 or 3 different stages. Where initially a district court judge would have to review the submission, if you will, and determine an initial stage whether it's valid. Then it's scheduled for hearing, the person can come in and contest the initial denial, the suspension of application of the FID card. The license to carry, when the person does apply in the community that they live in, the city or town, it's up to the police chief or physical designee to appoint someone to do an investigation into the person, their biographical history, criminal history, mental health history, perhaps any history that they have within the city or town, perhaps of anybody else, and they would either deny or allow license to carry application. The decision of the police chief is denied, it's reviewable, it's appealable to the district court. There was a hearing in front of the district court judge, then the police chief cannot be arbitrary or capricious. It has to be based on specific and articulable facts, evidence.
As your role as an attorney and or court magistrate, have you been part of those proceedings where someone takes an appeal to a judge after a police chief's denial?
I did not have any of those cases myself when I practiced. I have been in the courtroom when those appeal hearings have been heard.
What does it say there for the judge to decide whether or not the police chief used it?
In the amended statute in 2015, there is a suitability provision, the same as the police chief as we have. And it's based upon, there's a very vague reference in the statute to suitability, but it's based upon public safety. Whether there's a risk of harm to public safety based upon the specific particular facts or evidence that they may have.
So you're aware that the federal government, not the state government, the federal government has articulated a number of crimes that once convicted of, they can never carry a firearm. And that would include assault and battery, OUI, conviction. Not even a police chief or a judge can ever give that person a license.
Right, under the statute, there are exclusions. As you indicated, guilty felony convictions, assault and battery convictions, domestic violence convictions, etc. There's also exclusions for mental health.
And as a judge or a clerk, you wouldn't even have discretion to give that person a license. Is that correct?
That is, it's in the exclusion, that's correct.
And in your position, if you were affirmed to be a judge, would it be your position that there are some people, although not convicted, are not suitable to carry a firearm based on how they live their life within the community?
Well, I mean, if they're not excluded, if they're not one of the classes that are excluded, I would certainly conduct the hearing, and actually hearing, and determine, I'm sure the people that are suitable and maybe people that are unsuitable.
And what would you base that decision on?
I'm making a decision on the facts that I've heard in here in the courthouse, based upon the testimony, the evidence from the city and town solicitor, the police chief, the designee, and also from the applicant for the appealing party for the gun.
I appreciate that. As a police chief, I can tell you, I issued thousands of gun licenses. And I said no probably maybe 10 times. I wasn't appealed, because sometimes you have a nut in town who hasn't been convicted, but we've been to their house dozens of times for domestic and other things, but don't end up in a conviction. And I think it was represented that you didn't see a connection between guns and drugs. Is that true, though?
No, there's certainly a connection between guns and drugs. I represented several people charged with drug offenses combined with guns.
And there was a question about whether or not you think people had the right to alter their firearms to circumvent the law. And I was confused Do you think people can circumvent the law?
No.
As a judge, you uphold the law.
Absolutely.
I'm not sure where this right to assassinate came from my colleague, so I can't ask you a question about that. But we don't have, as a Commonwealth judiciary member, do you have any say over the right of people to gain arms and form militias, any of that stuff? What does that mean? Think people have a right, they're suitable, to have a firearm to protect themselves?
Yes.
Tell me about your take on the opiate crisis and your involvement in it.
The opiate crisis, it's enormous, it's scary to me, it's a great concern. I believe I read a study not too long ago, from the year 2000 to 2012, it was between 400 and 600 overdose deaths in Massachusetts. In 2014, I think it was almost quadrupled. It's a situation that certainly needs to be dealt with. There are a lot of cases in the trial court.